We are a few days away from motions for summary judgment being filed in the Lively versus Wayfarer case. I'm a Little Girl Attorney. I'm an employment attorney in California, and let's talk about what to expect with these upcoming filings. We've talked a lot about motions for summary judgment in previous videos, touching upon it throughout the way, but let's do a quick overview. Motions for summary judgment are typically filed by defendants, sometimes plaintiffs, but usually defendants in a lawsuit, and they're filed after the completion of all discovery, meaning that the parties have exchanged all potential evidence in this case. There's been a huge swath of exchange, in this case in particular. The parties have culled through all of the documents, have looked at everything to see what could serve as potential evidence for their claim or for their defense. And a motion for summary judgment is a chance for the party to explain why the other side loses their claims under the law and with respect to the facts. So, for example, retaliation under California law is one claim. Retaliation under federal law is a second claim. And there are many other claims in this case. But let's just use retaliation under California law as one example. Wayfarer parties can bring a motion to dismiss the retaliation claim under California law by asserting all the legal basis why the claim fails as a matter of law. So remember, the MJOP, the motion for judgment on the pleadings, does essentially the same thing. The difference is, at a motion for summary judgment stage, Wayfarer is able to produce evidence to show that there is no issue of fact, meaning there is no question as to the facts that would prove the defense, essentially. So if there is evidence that was uncovered in discovery, this would be the time to produce it with the motion for summary judgment to show why the claim fails. A very simple example is if there's a statute of limitations, meaning there's a timeline by which a claim needs to be brought under the law. And there is undisputed evidence that shows that the claim was not brought within the time. That's not something necessarily that they would be able to argue at an MJOP or motion to dismiss, because it might require the introduction of evidence to support that. So let's say that is one of the defenses and evidence is produced. They would win if the other side can't produce contradictory evidence. So in the example that I provided, Lively would have to produce evidence that conflicts with the evidence that Wayfarer produces for something like a filing within the statute of limitations. To make it more abstract, think of a car accident. Let's say that there's evidence that shows that the car passed the red light and smashed into the vehicle at 2:03 p.m. And let's say that there's data from the other side that confirms that the car ran through a red light and smashed into the other car at 2:03 p.m. There would be, therefore, no issue of fact as to whether or not the car passed a red light and crashed into the other car at 2:03 p.m. Now, how the other side might be able to create an issue of fact and therefore defeat a motion for summary judgment would to show evidence that actually the light was not red. There's evidence to suggest that it wasn't red, or there's evidence to suggest that it was a different car. That would put the issue of fact in question. That would defeat a motion for summary judgment. So it's very, very easy to defeat a motion for summary judgment if you can show there's a question that a jury will have to weigh credibility and decide. So this is why sexual harassment claims almost never win on motions for summary judgment. This is because one side will produce evidence that says, I never touched her, or I never said that, and all the other side has to do is say, actually, he did say that to me. And literally that's it. He said, she said, issue of fact goes to the jury. So the Wayfarer parties are going to be very careful about which claims they bring motion for summary judgment on. And you might see that they may not bring it as to all of the claims, because strategically, they should be bringing the motion against the claims that they feel they can win based off the evidence that was culled in discovery, and evidence that can't be refuted or put into question. The judge is not going to weigh one evidence over the other. The judge is only going to decide if there is a question as to whether there's a dispute over any of the evidence. If there is a dispute, he kicks it to the jury. A lot of people have asked me, are we going to see the evidence that the parties put in? Well, we have to look to the protective order. And in this protective order that all the parties signed on to, it said that all persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. Meaning that the parties are likely to file all the evidence despite it being marked as confidential and despite it having remained under seal previously. So it's going to be juicy. Now, there's going to be redactions with respect to personal identifying information, addresses, phone numbers, stuff that could really put somebody at risk, danger, will be redacted. But we will see unredacted scripts from the transcripts. We will see documents that have not been fought about. We will see text messages that we haven't seen. We will see emails that we haven't seen. We will see names of people associated with all of those things that we haven't seen. And that's because the judge is going to allow it. I'm literally drinking tea, but that's what it's going to be like. I've been thinking about this more as to why Lively might file a motion for summary judgment, because it's not typical for a plaintiff to do so. And I actually think it's because it's their opportunity to throw into the public things that they want the public to see when Wayfarer files its motion for summary judgment, as a distraction, honestly. Because with Wayfarer's motion is going to come a slew of evidence that proves they allege proves their defenses, why they win on the claims. And because this has become a war of PR, a litigation of reputation, that is why they would file a motion for summary judgment, to be able to enter as much damning information as they possibly can, even if they know it's not going to win. My prediction is that their filing is going to be even bigger than Wayfarer's somehow. Even though the parties agreed on a page limit, watch them add more exhibits. It also creates a lot of work and headache for the other side, because something that the other side can do when they're opposing a motion for summary judgment is challenge whether the evidence is actually evidence under the evidence code, and whether or not it can even be considered as evidence, which is a whole separate discussion that I don't have time for in this video. There will be no such thing as attorney's eyes only anymore. There will be no such thing as confidential anymore. All of the evidence that will be produced to support or refute the claims in the case. And unless there's something extremely sensitive, then one of the parties is going to have to seek relief from the court, and they're going to have to tell the court why they think that it deserves special treatment above and beyond what they all agreed to in the protective order at the outset of this case. So, who's ready for the tea?